Welcome to the 2020 Virtual National Institute on Healthcare Fraud, sponsored by the ABA Criminal Justice Section. This session is entitled Fraud and Abuse in Nursing Homes. Moderating this session is Thomas Barnard. Tom is a shareholder at Baker Donelson in Baltimore, Maryland. Tom, you may proceed with the program.
Thank you, and good afternoon. This is a good opportunity, and I appreciate you all turning out to watch this program. Joining me on this program is Jennifer Euler, who is the Chief Assistant Attorney General in California's Attorney General's Office of the Medicaid Fraud Control Unit. Please feel free to read our complete bios online. Now, today, the content of our program is going to focus on fraud and abuse in nursing homes. So we're going to start by explaining what we mean by that, because there's a lot of different aspects to the fraud and abuse in the nursing home context that's very unique compared to other healthcare facilities. We're going to talk a little bit about where to look, whether you're a government agency or an outside auditor or a private law firm conducting an internal review, or just management or in-house counsel. You have to have a systematic way of reviewing and looking into nursing homes. We're next going to talk about what we call the operational continuum, which is a nice way to organize potential fraud and abuse in your consideration. We talk about getting the patients, caring for the patients, and billing for the patients. Next, in a very current way, we'll generally talk about some of the CARES Act issues and some of the funding type enforcement we anticipate seeing in the near future, followed by a brief summary and conclusion, a chance to answer any of your questions about our presentation.
Okay, so I'm going to kind of take over what do we mean when we talk about fraud and abuse in nursing homes. And because I think most people on this webinar are pretty versed in this is going to be a very quick premiere where we just kind of walk through the highlights. It's not to be an in-depth lesson on fraud, like the False Claims Act or anything like that we may address. So first, what I want to say is healthcare fraud generally is the practice of improper, inflated, or otherwise unlawful medical billing. That's what we are typically talking about when we're talking about healthcare fraud in the or fraud in the healthcare arena. Fraud, even more generally, is an intentional deception or misrepresentation made by a person with the knowledge that the deception could result in some unauthorized benefit to himself or another person. More specifically, and what we're going to be addressing on today, is fraud, healthcare fraud in nursing homes. Several examples of those are listed below, which is billing for services not rendered, billing for medically unnecessary services or items, upcoding, kickbacks, falsifying your cost reports, unbundling, so on and so forth. And we are going to discuss more in depth a number of those topics a little further on. As a note before we move forward, both federal and state agencies investigate complaints of nursing home fraud and prosecute cases criminally and civilly. Most people are very aware of the U.S. Department of Justice and the U.S. Attorney's Office and their investigations and prosecutions, as well as state attorney general's offices. Not a lot of people, or I guess I would say fewer people, are familiar with the state Medicaid fraud control units, of which I am a member. The Medicaid fraud control units are states throughout are units throughout the country are responsible also for investigating and prosecuting Medicaid fraud and elder and dependent adult abuse. Next slide. Okay, so what are we talking about when we talk about abuse in nursing homes? So generally, when I think about abuse, just because of my job, I think of physical abuse, the willful infliction of injury, unreasonable confinement, intimidation or punishment that results in some sort of harm, whether it be physical or mental. However, in a healthcare fraud context, when people talk about abuse, it typically goes more towards provider practices that are inconsistent with sound fiscal, business, or medical practices and result in unnecessary costs. But because we don't really prosecute abuse in that way in healthcare fraud context, I'm going to focus more on the types of physical abuse that kind of go hand in hand with the fraud that we're going to be speaking more in depth on. Next slide. So types of physical abuse. When I think of physical abuse in a nursing home, I think sexual abuse, staff on resident incident. Maybe you have a staff member slap a resident because the resident spit at them, or you have resident on resident. You have a couple of residents with dementia, or one resident with dementia who is maybe violent or abusive to either resident or other staff. And then the other big one is unlawful restraints. And that can be either physical restraints where they're tying residents down with lap belts. It could be chemical restraints, maybe when they're giving every resident Benadryl on the night shift, or Haldol, or some other antipsychotic for staff convenience. It's a way to control the residents so that the staff don't have to work as hard, or the staff can actually have better control, especially if they are understaffed. Other types, that's the title of this slide is wrong. Anyway, financial abuse. We see financial abuse occurring in nursing homes when we have staff members come in, befriend a resident, maybe steal an ATM card, make purchases, steal a checkbook, make purchases, or even more significant is when they befriend a resident and become their power of attorney, and now they've got the keys to the kingdom. So we see that a lot in nursing homes as well. Emotional abuse, this can be the result of maybe verbal abuse. It could be the result of intimidation, fear of retaliation. We see that in a number of different forms. And then more specifically, especially when we're talking about fraud and abuse, is the systemic facility-wide neglect. And this is when you have hordes of residents who are suffering from malnutrition, dehydration, resulting weight loss. They're not getting proper wound treatment, and they're really just kind of being left to fend for themselves. I think now in kind of COVID times, we can also look at this as was there neglect where people, facilities were not using PPE properly, failing to cohort their residents, so on and so forth. So that is a big issue, the systemic facility-wide neglect. And that kind of goes hand in hand because, as you'll see, as we talk about maybe understaffing as a way to cut corners, you'll see more neglect affecting more patients in a facility. Next slide, please. Okay, back in March, the very beginning of March, when the world was still basically normal, the US DOJ announced this National Nursing Home Initiative. Attorney General Barr came out and said, we are going to look even more specifically into homes, nursing homes that consistently failed to provide adequate care. And so that's adequate nursing staff, that's adhering to basic protocols of hygiene and infection control. Who knew how much that would be in the spotlight, weeks later. Failure to provide residents with enough food to eat, facilities that withheld pain medication, or facilities that used chemical restraints or, as we spoke about, to restrain their residents. So the US DOJ was looking at these types of failures and decided that they were going to embark on this new initiative that really focused on nursing home care. And then fast forward maybe a few weeks, maybe 1 week, and COVID hit us, and we all, unfortunately, most of the agents had to take a step back. So the surveying agencies throughout the state who would go in and typically investigate complaints or do surveys of the facilities could not enter the facility. And I think now are just now getting back in, or have been getting back in, but in a limited basis. And so even though this nursing home initiative was announced, I think the government really had to shift the way that they were going about prosecuting these cases. And we can talk about that a little bit more in depth later as well. Next slide. Okay, after we talked about fraud, abuse, this new initiative, what types of causes of action does the government typically use to prosecute these types of cases? So there's generally the fraud statute, and that could be a federal fraud statute, or it could also be individual state fraud statutes. More importantly, and the one I think that is used even more than the fraud statute, is the Federal False Claims Act. The Federal False Claims Act is a tool that, generally speaking, creates liability for a person who knowingly submits a false claim, or causes another person to submit a false claim to the government, or makes a false record in order to get payment from the government. Why it's used so much, I believe, is because of the damages and penalties. So under a False Claims Act action, if the defendant is found guilty, they have to pay a civil penalty somewhere between $5,500 and $11,000 for each false claim, and they're subject to treble the amount of the damages. So 3 times the damages, whether that's the overpayment, they have to pay that back. And the False Claims Act does have a knowledge requirement, though. So it's not a strict liability cause of action. In order to violate the False Claims Act, the person must have submitted or caused to be submitted the false claim with knowledge of the falsity. Now, the knowledge of the false information is 1, either actual knowledge, 2, deliberate ignorance of truth to the truth or falsity of the information, or 3, just a reckless disregard of the truth or falsity of the information. And then just kind of as a subset, and something that our governments use, and I say our governments meaning state government and then federal government, use quite often, is the qui tam provisions of the False Claims Act. So the False Claims Act allows private individuals, private citizens, to file suits for violations of the False Claims Act on behalf of the government. And then it provides the federal government or the states with an opportunity to intervene. These are obviously called qui tam actions, and the person bringing the suit is your relator. All right, so that's enough on the False Claims Act. At least 29 other states have enacted False Claims Act, State False Claims Act. I know California, we have one. And these provide the state governments with an opportunity to go after the same types of claims as the federal government statute. Another cause of action that we use quite frequently, at least in California, are those that fall under the consumer protection laws. These can be both criminal or civil. In California, for example, we use the unfair competition law quite frequently, which does have either a criminal or civil penalty provision or component. These are basically, you can go after anything that's being violated that can be considered an unfair business practice. So it's a very general and broad law that is intended to protect consumers. And we use this quite frequently, especially when we're looking at nursing home chains who systemically or have a policy of understaffing that results in harm to the residents, and so on and so forth. So that is a really useful one. Check into your states if you haven't already. What are the consumer protection laws in your states? The other 2 that are used quite frequently are causes of action are the Stark Law, which Stark Law basically prohibits a physician from referring Medicare and Medicaid patients for designated health services to an entity in which either that physician or a family member has a financial relationship. And then it prohibits the designated health services entity from submitting claims to Medicare and Medicaid for those services. There's no intent standard for the overpayment. So it's a strict liability statute or a strict liability cause of action as far as the overpayment is concerned. This is a civil action with civil remedies. So the government can recover the overpayment. You can also do a False Claims Act based on the Stark Law violations. You're entitled to civil monetary penalties. And even more importantly, maybe for a lot of these actions is program exclusion. So program exclusion happens when a healthcare provider violates a law, either fraud or elder abuse or neglect, and they're found guilty, or sometimes it's even if they're charged, where they're now excluded from the program. So that means they cannot participate or be employed by or receive funds from any institution that receives Medicare or Medicaid money. And that is huge. That's a big hammer. And so that's why you'll see a lot of defendants really fight hard for a lot of these claims, even if it's not a fraud claim of action. I know in California, we have a failure to report claim of action. If you fail to report of elder abuse that happened in a nursing home, that is a misdemeanor, but that being convicted of that misdemeanor will also get you excluded from the program. And so that is a really big consequence for these types of actions, and that is available under the Stark Law. You also have the potential under the Stark Law for up to $15,000 civil money penalties, and then a civil assessment of about trouble damages. Okay, then if we look at the anti-kickback statute, that statute prohibits offering, paying, soliciting, or receiving anything of value to induce or reward referrals. So basically, you have the instance where, hey, doctor, I'll give you $10,000, or I'll give you this. What we see more frequently is I'll give you this medical director position in my facility if you refer your patients to me for service and treatment. And so with those, you have either criminal or civil penalties and remedies. For criminal, you can face up to $25,000 per violation and a 5-year prison term per violation. So that is also a pretty big hammer. And then on the civil and administrative side, again, you open yourself up to False Claims Act liability, civil monetary penalties, and program exclusion, which we addressed earlier. The potential of up to $50,000 civil money penalty per violation, and a civil assessment of up to 3 times the amount of the kickback. And then while the Stark Law only applies to Medicare and Medicaid programs, anti-kickback statutes apply to all federal healthcare programs. All right, next slide. I'm going to pass it over to Tom.
Thank you very much, Jennifer. So, it's a big operation sometimes, these nursing homes, and there's a lot of moving parts. But as the statutes that Jennifer just went over, understanding how the statutes work help guide where to look. Under the False Claims Act, it's not simply about submitting a claim that has a false, number in it or a false piece of information. The False Claims Act can be violated and false based on violating things that are called conditions of payment. Those are things that are seldom explicitly talked about during the form of billing, but are implied conditions often, or essentially are certifying compliance. So that means the scope of where the basis for fraud can be in many, many forms. So knowing how to find it and to stop it, because that's what our jobs are, is to require an understanding of how it works. You got to really know the operation of a nursing home. How do they make their money? What is the role of each person? How are patients cared for and billed? And how does the business really function? Where are their bank accounts? Who has access? We understand the personalities of the people involved. So, for instance, let's say you have a nursing home that's owned by a person who is really an equity fund. Let's say an equity fund owns a nursing home and then hires contracts out. There could be conditions and statutes particular to a particular state on the ownership structure and management structure. In some states, you can transfer the operation, the licensed operator can completely transfer the operations to another person working under their jurisdiction, where in another state, possibly it's not permitted under their state health laws. The owners and understanding the personalities of the management and how it's worked can help guide you where to look, because you start to see, well, who's making money and who's not. The compensation structure will really drive that. So, for instance, if there's a compensation structure that's driven by, census, driven by profits, what drives the money and what drives compensation can help lead you where to look. As the old expression goes, in our business, following the money is always the safest path. Next, you look at the relationship with third parties. It's amazing. I'm sure Jennifer and her investigators will show you can go to some nursing homes and there's never any visitors. There's hardly any visitors or third parties. Then you go to another nursing home, which is booming full of census, and there's like visitors from every possible vendor and this specialist and that specialist and this person selling DME supplies, this person selling pharmacy. Constantly they're visiting. So you have to ask yourself, what's the cultural difference and why? What are some indicators that there could be a problem? Is every day the staff at the facility get free lunch provided by an outside vendor? I mean, that's probably a good indicator that there's something to look into. And what are they trained? So we look at do they have a regular compliance person with a systematic annual training program? Those are all things where you can look behind the curtain and start to get some general pointers on where to look. Next slide. So There's really four factors. If I'm going to do an internal investigation, which is typically what I am engaged in now, since I'm in private practice, is the economics. Understand there's four factors in my mind, at least how I organize it, that really segregates the economics of a nursing home. One, they get paid by census. So they're naturally, it's like any business, you want to be full. If your bed has a certificate of need approved for 257 beds, your goal is to try and have that full of 257 patients, because that's what you've been certified for, and that's how you make your money. Next, the reimbursement, you have to offset it with the cost. So you want to be the most efficient as possible. You want to have staffing at the appropriate level and supplies at the appropriate level. You don't want to have people sitting around not working, and you don't want to have supplies that are going bad because you're constantly buying too much food and things that go to waste. The third is you want to maximize reimbursement. You want to make sure that your cost reports and your potential to reimburse within the law are maximized. You don't want to be, as they say, leaving money on the table at the end of the day, because then you're just running a business poorly. And I think, there's nothing in the law that prohibits people from running their business well. In fact, it's in everyone's interest that these are run well, because then they survive and being profitable. They encourage the nurses and staff to be paid more. The problem is we get to is, when do you put profits over patient interests? That's the ownership and the management structure. The other thing is you want to look for is the people who own the facility and the operation have a vested interest in the care and well-being of the patients. If it's a distant third party owned through a shell corporation and a holding company that owns the property, that hires, the more layers removed the ownership is, you start to worry about, how is the money getting to those people? Where is the money flowing? And what are they getting paid? And if they're putting pressure on a nursing home to reduce costs, what is the consequence of that? And how are they structured? So these are all kind of, you go through these systematically and you start to find if there's a problem. You do it this way because oftentimes you don't have the benefit, or you do have the benefit, of a whistleblower who points you to one of these. But chances are, in most whistleblowers I've seen, they tend to fall into one of these categories, most of the allegations I've seen. So next slide, please. So let's talk about maximizing censuses. So if you think about the lifespan of how you get a patient, there's an admissions team or an admissions section or somebody who in-processes new patients, and there's a set of qualifications in the CMS guidance of who's eligible to be in a nursing home. So the question is, who's making those decisions? I would say 100 times out of 100, the rule would be that a clinical person makes the decision on whether or not someone is eligible for care in a particular type of long-term care facility that meets the criteria and that kind of thing. There could be administrative reasons why they're not eligible, but typically they must meet certain criteria to be qualified to be reimbursed. So one of the first indicators that would be a problem you might look at is someone from marketing on the admissions council, or someone from the business development have a vote in or overriding vote in who gets admitted. So that's an indicator. So where do most admissions come from? There's another one. If you find it, this is just how the government may look at it as well when they do a statistical analysis. Do you find a predominant referral source over all other referral sources? It could be totally fine, but it is a red flag. If you find 9% of these nursing home patients come from the same physician or physician group or the same hospital and they all get referred, or something like that, you have to ask yourself why. Could be that they're in a rural setting and that's the only other place that they can come from. Or it could be that there's an improper financial relationship with that referral source. So you just have to rule it out when you see statistical anomalies. You have repeat admissions. I don't know how much this is a problem in the nursing home context, but it does happen where people are admitted, they leave, they come back, they leave, often referred to as patient churning. They may go from one facility to another. This is sometimes a way, maybe more frequent in like a hospice or other types of facilities, but could be in a nursing home. That's a warning sign where you continually trying to get people in and out of these facilities. Averages over time. What's the average stay? The length of stay is another indicator to look at. There's averages that are published nationwide, and if your facility is, for your area is significantly different, there's probably something to look at there. The last thing is, what's really driving the census for the facility? Is it the bed space? Is it the relationships? Is it the community? You have to look at what's going on. What kind of marketing staff does the facility employ? How do they market? And what's really pushing, what's their number one way in which they get new patients? So those are all things that might, when you're going to evaluate census, that's a good place to start. Census is the number one revenue driver. Next slide, please. So then we talk about minimizing costs. And as Jennifer alluded to, this is probably where many, many investigations come for. And it can come in many, and we'll talk a number of theories that relate to this. But again, who is managing the staffing? Who decides how many nurses, how many therapists, how many nurses' aides are present at a particular time and a particular day? In the nursing home context, there is guidance put out sometimes under the state law, sometimes under and the CMS regulations put out staffing ratios. Who's monitoring that? Again, these should be clinical decisions as to what is medically necessary. And it can't simply just be in numbers. It can't just be, well, we have this many patients, this many staff. That's the starting point. But then you have to look at things like the severity of the patient. Do you have a particular wing that's, a number of people with severe dementia or other things like that anyone would look at and say, you cannot have the minimal staffing when you have this kind of high need patient? Is the director of nursing monitoring it? Is the director of nursing's voice being heard in management meetings when it comes to these things? These are all kind of important things. Oftentimes, as we'll talk about this, overtime and the use of outside agency for assistance is one of the biggest drivers in costs. Overtime obviously is a time and a half type situation, and agency is normally much more expensive on cost because you're paying all the fringe benefits and things. At least in the short term, it's more expensive than hiring full-time employees. So the question is, how often is an entity using outside agency and overtime? High degrees of overtime is a strong indication that the staff is being overworked and are not properly staffed. A high use of agency means that the entity probably isn't operating very efficiently and are covering themselves by the use of agency. And then you have to wonder, how far behind are they in paying the bills to the agencies that they're using? It could be that they're very far behind and at risk of missing or lacking adequate staff. Next slide, please. So then the next big component we talked about was getting reimbursed. That you don't really start making money until you start getting reimbursed by the payers. Usually it's the Social Security, or not Social Security, Medicare and Medicaid. To do that, annually they must file the facility must file cost reports. And the cost reports deals with calculating how much does it cost to care for the types of patients you have on average. So these cost reports, a lot of data goes into that. And then the question is, who is preparing them and how accurate they are, and who is managing the billing activity. Now, in a particular nursing home, there could be other billers on the property, because nursing homes are billed on a per diem basis based on cost averages for the year. There's other people on board, specialists, who may bill individual provider codes. So that's a valuable access. If I'm the person who does, say, wound care for a nursing home facility and I have exclusive rights to being in there providing wound care, that's a valuable commodity to me. So how is it that they have that relationship, and is there any other relationship between that wound care facility and the nursing home? Something to look at. Who's periodically auditing the bills? If you have a facility that's been billing for years and they've never had an internal audit done, never had anyone look at it to make sure it's accurate or check their cost reports, it should be some sort of level of review should be happening. Otherwise, you just don't know if there's a problem. Next slide.
And Tom, before you turn to the next slide, I just want to a little bit here on the cost reports. So this is a tool that we have used in enforcements both criminally and civilly. We pull our reporting from what we call we call them OSHPD reports, and right now I'm totally missing the acronym. It's like State Housing and Development reports. The problem, and I think Tom and I discussed this as we were preparing for this webinar, is that the OSHPDs take a little while to get finalized. They lag a little bit. So for a quick picture, snapshot of what's happening in the facility right now, these aren't good tools. But to look retroactively, to look back at what the facility has been doing, these are great tools. Especially, we did a case where we had some significant understaffing issues, and we were able to use their cost reports and look at how much, based on the staffing that we had calculated, how much they were basically reporting incorrectly on the OSHPD to set rates for reimbursement. And we were able to use those cost reports to define our damages range. Like, here's the minimum that we can do based on different theories, and here are the maximum based on their own numbers in their own cost reports. So it can be a really useful tool. Another thing that Tom mentioned briefly was, and I think we may speak a little bit more about in a moment, is management companies. Who's the management company? Is it the same group of people who own the facility? They also now have the management company, and they own the property. Where is that money going? And is it all the same people with 6 different corporations? Not saying there's anything wrong with that, but how much money is being sent out of the facility and away from patient care into the pockets of the owners of these other corporations? So these are really good tools. But just know it's kind of a retrospective look.
It's a good point, Jennifer. And I think when we look at cost reports, one of the things you look for is these phrases called management fees that are on there that are paid to the management companies. And oftentimes, if it's a management company that's really just not doing anything, you have to ask yourself, what is this money being paid for? It's okay to pay for management services as long as some actual work is being performed. You can't just use it as a way to send more money to the owners.
Mm-hmm. And what we can also do, what we've done in the past, is we see a management company that's getting paid a pretty hefty fee. We want a contract. Like, send us a contract of that between the management company and the facility. Let's see what they're actually responsible for. So that's another tool and another place to look.
Yeah. Another thing on the cost reports, it's also something that we'll talk about some more examples. But people who own chains of nursing homes, when we look at chains, there's a risk of, when you buy supplies or supply costs, there's a way to maybe double count those things in multiple facilities when really you're not spending it in order to inflate, finding ways to inflate cost reports over time to elevate your reimbursement rate is if you own a chain or the ability to do that, it's something you could do. So there's all kinds of things people may do to try and inflate these costs.
Or if you own the nursing home chain and you own the DME company as well, inflate costs that way too. So
those suppliers are always an indicator you have to look at. Okay, so next slide. So, and then as we were getting to, that management structure is a big deal. So who controls the bank accounts? If you're the administrator, you ought to have access to all the bank accounts in order to access money, because you're the one who has to divide how to pay for various needs. But if the bank accounts are essentially run by the owner or an outside company and you can't have access, or you don't have visibility on how that money goes, it could be a problem. How are they paid? What are the fees that go to the owners? Is there a profit share? How is it calculated and how does that work? These are all things that will be closely analyzed by investigators. Often, the owner of the real estate may be different than the owner of the operation, and the relationship, is it a lease? Is it how is it structured? And is there actually a common person involved in the real estate and the operation who is essentially paying themselves, and is the rent at fair market value? So these are all questions that we have to talk about. Next slide. So now, as we get into some real weeds about looking for this fraud, we're looking at what I call the operational continuum. Getting the patients, caring for the patients, and billing for the patients. If you go to do an internal investigation, it's always good, or even a government investigation, if you're out there doing this, you follow along the continuum. It keeps you organized, and it lets you follow a patient from start to finish. How do they get paid? How do they get them? How do they care for them? And how do they get paid for them? Next slide. So relationship with referrals and recruiting efforts and admissions requirements. We talked briefly about them, but let's go in a little more detail. So it could be in a nursing home that you have a relationship, you have out marketers or business development personnel that visit various hospitals or doctors' offices to alert the doctor to their availability and how how they're going to what kind of services they offer. Every nursing home has a different level of service. They sometimes offer more specialty services. Some are higher quality. And so it's natural that, a doctor would want to know the various options because, let's face it, a patient is going to ask their physician or someone who provides them, do you know any good work? If you want me to put my father, my mother in a nursing home, are you recommending that for their safety? What are some ones that you recommend? So it's not unusual that a doctor would be put in that kind of position. And there's nothing wrong with the doctor making a recommendation, as long as they don't do it based on an improper financial relationship. Well, an improper financial relationship, if you look at the anti-kickback statute, is anything that is likely to induce a decision or a recommendation or a referral. There are some safe harbors and some things, and we're not going to do an AKS class today. But generally, there's, one thing I always hear is, well, it was de minimis. There's really no straight up de minimis kind of exception. Even if it's $50 per referral, let's say I'm a doctor and I refer to 30 patients a year. That's money. 200 patients or something. You just never know. Let's say there's a side agreement with this as well. If you do this, we'll make sure if we have any patients who get sick, we always call you to come provide the care. Now, maybe that's not something that's a direct financial, but it's a clear financial relationship. The recruiting efforts. Do you direct market to patients? Some of this, especially the telemedicine and the online world, has changed some of the rules. You can't, patients have to make an outreach to show an interest. You can't just start, going directly to them in doctors' offices. Usually, there's some privacy, there's some HIPAA implications as well. Then the admissions requirements. You have to go and really look at the admissions requirements to make sure people are qualified. Somebody who has certain comorbidities or things that cannot be cared for in a certain level of nursing home, you can't admit, knowing that you can't provide the necessary care that's needed. People with severe wounds, people with sometimes dialysis issues or other things that may not be. You have a home with certain size rooms or different things that you can't provide for. You have to be very careful about your admissions. So these are all areas that I have seen instances where there has been false claims or fraud or efforts to violate just to increase census.
Yeah, and on the same topic, when we're looking about recruiting efforts, are all the patients coming from one hospital? Are all the patients being sent over by the same discharge planner from a hospital? If so, maybe that's an avenue where we need to look at and say, what's being provided to this discharge planner that they're sending all of this hospital's patients to this same facility? Is there a kickback there? Is there a financial incentive? And again, as Tom said, follow the money, right? If there is money being given to a discharge planner, and sometimes you'll see, oh, it's a Starbucks gift card, it's this, it's that, it's that can also be improper. So that's one place to look. The other thing we've seen a lot of our placement services, I can't think of any off the top of my head that I'm free to talk about, but when placement services are getting some sort of kickback for placing residents in homes, what is the relationship there? So how, like Tom said, how did the resident end up in the facility? That's a great place to start, especially if you see a ton of people coming from the same source.
So in a hypothetical we could talk about is, let's say there's a telemedicine company that, maybe in a rural community or because of COVID, people aren't able to go see their normal primary care physician. But the family believes that their loved one is probably getting it appropriate for a nursing home. So they reach out and they reach out to the telemedicine company that operates remotely but refers and makes a finding that patients should be cared for in a nursing home, meeting the eligibility criteria. Well, if I'm a nursing home and I reach out to, let's say it's called, let's just make up a name like, alwaysavailabledocs.com or something like that. But I, as a nursing home, reach out to them and say, look, we got contacted by a patient. We'd like to get them admitted. You review this patient. We'll set you up with an appointment. If you look at them and they get referred to us, or you believe they meet the eligible criteria, our facility will pay your fee, or our facility will pay you a fee one if you find that they're eligible for a nursing home, or fee two, which is just an eval fee that you don't get anything if they don't get referred here. So you could see, and it's a common thing we're seeing across the country in other contexts, but a relationship with telemedicine companies that work remotely, that they could be used in a way to create a steady stream of patients for referral to a long-term care facility. So those are kind of the hypotheticals to look at. The era of telemedicine has made that something that I think the government is looking at more and more, is these relationships. I know that as an assistant U.S. attorney, when I used to do that, we would get data dumps, I think quarterly, from the STARS data that would tell us who are the hot spots. People have statistical anomalies of relationships between referral sources. It would give us the top 5 people who had abnormally top 5 relationships, and you could set it by types of referral sources. So, I mean, these are things that the government will look at, and if you're doing an internal review, you should be conscious of, do I want to look at the internal sourcing for our facility? Is it abnormal? Do we have a concern?
Another weird instance that we came across out here in California was we had a facility where the facility had a very low census. This was pre-COVID, very low census. It was a bad facility, very one or two stars. I can't recall exactly. And they were just having a hard time recruiting, getting patients in. And so we had an administrator who went to other facilities in the surrounding neighborhood and said, hey, you give me your problem patients, your most, your highest acuity, your troublemakers, send them to me and I'll give you $1,000 per patient, right? So not only do we have some issues on, is this a kickback? What's going on here? But then you also had to look at what kind of care were these high acuity problem patients going to receive at this 1 to 2 level facility, 1 to 2 star facility. So also kind of another indicator, again, looking at where did the patients come from.
Yeah. Okay. And that's a good point, because I do think, as we talk about the revenue and the minimizing costs, nursing home wants simple patients. They don't want complicated patients in most cases, because the lower their costs, the higher margin off their reimbursement rates.
Mm-hmm.
All right, so let's see the next slide. Okay, so this is probably, and Jennifer, why don't you talk about this?
Sure. So when we look at caring for the patient, one of the things is the staffing. What are the staffing levels? Does the facility have the appropriate number of staffing? And when you look at the federal staffing regulations, basically, federal law just requires that nursing homes have enough staff to meet the needs of the residents. It doesn't necessarily prescribe a specific number of, for example, nurses' aides, right? So typically, when you have a Medicare and Medicaid certified nursing home, they have to have a registered nurse on duty at least 8 hours a day, 7 days a week. A lot of times we find out that person is the director of nurses. Or nursing, and not necessarily even doing a lot of work on the floor. But then they also have to have a licensed nurse on duty 24 hours a day. But again, no real minimum or mandated staffing level for the nurses' aides who provide the care. They are the people who are going to be rotating the residents, toileting the residents, feeding the residents, so on and so forth. So maybe you have a licensed nurse who's doing the med pass, but really there's no national prescribed level for nursing assistants. However, states have their own standards, right? So I know out here in California, we recently upped our state standard to 3.5 nursing hours per patient day. That sounds great in theory. However, another thing we write on here is there are things called staffing waivers. So even in California, where it has to be 3.5 nursing hours per patient day, of which 2.4 of those hours have to be by nurses' aides, facilities can apply for a staffing waiver based on a workforce shortage. So say they're in an area, a rural area, where their workforce is limited and they can't meet 2.4 or 3.5. They can't use registry or agencies in order to get more nurses in. They can apply for a waiver. So make sure you know, if you're looking into one of these facilities, if that facility has actually applied for a waiver. Are they meeting the standards that they have to meet based on a granted or approved waiver? The other thing to look at when we're talking about staffing is staffing ratios in particular facilities. So at least out here in California, our skilled nursing facilities have 3.5, but then our subacute skilled nursing facilities, or the subacute facilities, have to have a higher standard and, a higher number of nursing hours per patient day. And what we've encountered here in the past, and we actually prosecuted civilly, was we had a nursing home that had a subacute floor and a regular skilled nursing floor. And you would have a different place, like a Chronos system, to log in or to sign in, whatever it is, clock in, if you were going to the subacute or if you were going to the regular skilled nursing floor. And in this facility, they were short on the nurses for the subacute floor. So what would happen is the nurses for the skilled floor would go up, clock in the subacute floor, and go and do their hours in the skilled floor instead of in the subacute. But they were being billed as though they were providing care on the subacute floor. So that is a big no-no. That's fraud. So we ended up prosecuting and were successful in that case. So just be aware, what type of facility are you dealing with? Are you dealing with a subacute? Are you dealing with just a regular skilled nursing facility? And know if your state has specific staffing standards. If they don't, you can go back to the federal staffing standard, which is that they have to have enough staff to meet the nursing home's needs, the residents of the nursing home residents' needs. If they're in a subacute, that's just assuming that their acuity is going to be higher. They're going to need more care. So they're going to have more staffing than a more higher staffing ratio than facilities that are just providing regular skilled care. Another kind of thing that you need to take into consideration now, and we'll talk about it a little bit later, is staffing waivers due to COVID. When the COVID pandemic began, California, who I said had a 3.5 nursing hour per patient day requirement, waived that as well for COVID. So now we have people in a COVID pandemic where you have to cohort and only some staff can go and work with certain residents, but now we're waiving our staffing requirements. So that is potentially dangerous to the residents of the nursing home, but it's also something that you need to take into consideration if you're looking at this fraud aspect. And while we're on the topic, because it's fresh in my mind, out here in California, when nursing homes during COVID were having a problem getting appropriate staffing or having their staff report to work, either because they were sick or scared to show up, sometimes the National Guard would be deployed, or we also had these California medical assistance teams that were deployed to facilities. The big question and what we're kind of waiting to see is, how are the facilities billing for that? Are they saying that they were staffing the whole time? Are they going to bill for the time that the personnel from the National Guard and CalMat actually spent on their floors doing the job of their nurses and nurses' aides? So that's another thing to look out for. Next slide, please. Okay, so this is also talking about the type of care. Yes, all right. So when we're looking at especially False Claims Act cases, first of all, it's a nursing home's responsibility to ensure that services provided meet the minimum statutory standards before they can file a claim for reimbursement. What the big issue that we face in FCA cases is, do the services rendered and were billed for, do they amount to worthless services? Worthless services is the performance of services that was so deficient that for all practical purposes, it was equivalent to no services at all. That is a high standard. Worthless services, it's a tough, and I think Tom will tell you, it's a very tough standard for the government to achieve, because I've heard arguments where, hey, these services weren't worthless. We provided you with a place to stay. That's not worthless. That has some value. So there is an argument that this is so if you're trying to, as a government agency, pursue FCA and put it on this type of worthless services type platform or theory, it's a very high standard to meet. There have been cases throughout, I think there are even cases, a recent 2020 case in Pennsylvania that talked about, based on the Moments case, which established the worthless services, that said, a nursing home that does not care for its residents in a way that promotes their quality of life may be liable under worthless services theory. But more than mere regulatory noncompliance is required for liability to attach. The noncompliance must be so great that effectively no services were provided, right? So even if in an FCA case, a relator was able to demonstrate that the care that was given was negligent, that's insufficient to allow a reasonable inference that there was a factually false claim submitted. So this is a very high standard for the government to meet. I don't know if, Tom, you wanted to add more to that?
Yeah, just to add that, when you get into these, there's conditions that, you have to meet to be worthless or not worthless. You have to be very careful that you're looking at conditions of payment versus just conditions of participation.
Correct.
Much of CMS and even state regulations are divided along those lines. And I think courts have pretty clearly held it's going to be conditions of payment that can be the basis of a False Claims Act, not merely conditions of participation in the program. So it's another layer, at least if you're looking at it from the defense side, to know what you're looking at from the government side to make sure you pick a condition that's going to be able to stand court scrutiny.
Mm-hmm. And also for the government side, you have to know whether your single state agency is going to stand up in court and say this is a condition of payment and not, oh, this is just merely a condition of participation. So just that's another feather for your hat. All right. Next slide, please. Okay, also on the caring for the patient in this part of the continuum, there are a number of services that you can look at that can either be an indicator of fraud occurring, an indicator of neglect, an indicator of a number of things going wrong in the facility. One is rehabilitative services. This is an area that, at least until, January or so, this was an area that was ripe for fraud in that Medicare was paying for rehabilitative services, and I personally would go into facilities and there'd be the rehab schedule and it was filled up and the rehab rooms were empty, and the people who were in there who were supposed to be providing physical therapy and speech therapy and occupational therapy were nowhere around, or they were huddled around the nurse's station, or they were in the rehab room talking amongst themselves. So they weren't in the rooms actually providing therapy, even though when you looked at the log for the day, the calendar for the day, it was packed in 15, 25-minute intervals. So that's one area when we talk about rehabilitative services. The other thing, and this is, I'm sure most people in the webinar today are aware of, are the RUG rates. And that is facilities inflating the rehabilitation rates to get higher reimbursement from Medicare. We saw a lot of that in the last 10 years. And I think, if I'm not mistaken, Tom's going to go a little bit more in depth on that. Right, Tom? I think so.
Yeah, a little bit.
Yeah, okay. So we're not going to spend a lot of time on that. The other couple things that I think Tom's going to cover a little bit as well is just outside services for wound care and dental care. But look, when we're dealing with wound care that's provided in the facility, is proper wound care being provided for people who have pressure ulcers, surgical wounds, diabetic ulcers, whatever that is, whatever their wounds are, what is the treatment being provided? Do you have a whole slew of residents who have non-healing pressure ulcers, or they came in without any ulcers and now they all have stage 4 unstageable pressure ulcers? Do you have people who were at high risk of pressure ulcers or low risk of pressure ulcers and now they have ulcers? That is indicative of understaffing, potentially, right? It could be they don't have enough staff in the facility to properly turn and rotate the residents. They don't have enough staff in the facility to get the residents out of bed or out of their wheelchair. So they're sitting there and their skin is just wasting away. It kind of also goes hand in hand with malnutrition and dehydration. Is there not enough staff to assist with mealtime? If you have people who need full assists or partial assists with food, are you walking in a facility and they have their tray at their bedside untouched before it's taken away because they're so understaffed, nobody can feed them? Or the facility is so understaffed that they can't get the resident out of bed and brought into the kitchen where they can have more assistance. So wound care and treatment logs, these are a great thing to look at when we are looking at systemic neglect in a facility. We very frequently find ourselves looking at the treatment logs for the wound care, skin conditions, it gives you a nice picture of what's happening in that facility. Dental care. This is typically outside providers coming in to provide dental care when I think of it. And this is an area that's ripe for fraud because you have outside providers coming into a facility, and in one instance, we had them doing teeth extractions on every single tooth in a resident's mouth, right? And then you have unbundling of services where, they pulled one tooth one day, one tooth the next day, one tooth the following day. So these are red flags for to look at. Is there a medical necessity or a real reason to have every single tooth pulled in a resident's, a 98-year-old resident's mouth? Or were they actually coming in on multiple days, or were these services all provided at the same day and have just been unbundled? Malnutrition, dehydration, I talked about a little bit, this is an indicator of poor staffing. During COVID times, that's what I am getting a lot of. I'm getting a lot of complaints regarding malnutrition and dehydration. It's not so much that people are dying from COVID necessarily, it's people are suffering from malnutrition and dehydration because the facility is understaffed, because staff either are sick or afraid to come in because of COVID, or they're being cohorted and people don't want to provide care to the people who are in the COVID positive wings of the facility. So they end up suffering from malnutrition, dehydration, improper wound care, things like that. Two more things. Listed here, but illegal or unsafe discharges. And these are, when we're talking about caring for a patient, do you have a problem patient? What do you do with a problem patient who takes up a ton of staff time, who's causing problems, who maybe is wandering the halls at night or is vocal, needs a lot of care? Well, in a lot of instances, we see nursing homes discharge them because sometimes that's the easiest route. But discharges from nursing homes have to be safe. A patient is entitled to written notice, 30 days in advance in most circumstances, and the discharge has to be planned out so that it is a safe discharge that is not going to endanger the resident. What we've seen a lot of is facilities have a problem resident and they discharge them to a hotel, a motel, a taxi, with no idea where the final destination is, or to the last known address of the resident's cousin, So really, and without meds, without the diabetes supplies, without whatever. So you got to look at, are they getting rid of, are there a lot of discharges occurring in the facility? Are these people who are high acuity, who maybe were problems in the past? What's going on? Or are these safe and legal discharges? Another thing that we've looked at in the past has been what we call patient cycling. It's less now because of COVID, and we can address that a little bit later. But, you had to have a 3-day qualifying stay for Medicare to pick up the tab for nursing home stay, the first 100 days in a nursing home stay. And so once the Medicare reimbursement was about to switch to Medicaid, then we'd see a lot of discharges, like right at once the Medicare is out, they're getting the patient either out of their facility or back into a hospital to re-up their stay, their Medicare reimbursement. So look out for patient cycling. What do the discharges look like? Are they happening on the 100th day? Are they happening in an unsafe manner? Are they happening without notice? And then finally, one thing I didn't get on the slide was hospice services. To qualify for hospice, you have to have a prognosis of 6 months, a terminal disease or illness, and a prognosis of less than 6 months. What we are seeing time and time again are hospice stays that are years long, right? And that doesn't mean, hey, maybe one person is outlasting their prognosis. It means, we're seeing a pattern of hospice patients inside facilities who are just extending beyond the 6 months. And so take a look at that as well. And that could be one where you have hospice coming into the facility, and maybe it's not the facility itself that's engaging in fraud, but the outside hospice provider. We've had instances where the medical director the medical director for the hospice company certifies a resident for hospice without seeing them, looking at their medical records, anything like that. And then they're just on hospice for years. So that's another area that's really ripe for fraud. And it can take, once you know what to look for, it's easy to find. All right, Tom, anything on that? If not, I'm going to turn it over to you for the next slide.
Let's go ahead.
Right.
Sounds good. So we talked briefly about the specialty providers, but just understand, again, this goes back to understanding the economics of nursing home. Certain types of care a nursing home is required to provide as part of just being a nursing home. So wound cares, and they have different levels of wounds, and there's a whole technical definition of types of wounds. So if nursing home would have to provide internally care for certain type 1 and 2, let's say. But if it goes beyond a certain level, then you need a specialty provider. Now, a specialty provider gets to bill for their time and their resources using CPT codes, the provider type reimbursement. And the nursing home is then not obligated to provide that care. So there is sometimes an incentive for a nursing home to try and get more and more anything that would be time-consuming or expensive to care for rated to be cared for by a specialty provider, because then they get separate reimbursement and it doesn't come off the top for any the per diem for the nursing home. Same with DME, various durable medical equipment. There's certain types of things that have to be provided by the nursing home as part of just their per diem, but some things up to a certain level can be billed separately and reimbursed for. So that's just some things to think about, is understanding when you get into, if you're operating or advising a nursing home, is what are those levels? What are the different things? And let's say on an average 200-bed nursing home, they have, the government look at it and say the average 200-bed nursing home might get 50 specialty care, wound care visits a month, okay? But for some reason, this particular nursing home gets 100 a month. See, that's the kind of statistic that's going to stand out to the government, and it should stand out to you during an internal review. So additionally, if pharmacy, the relationship with the pharmacy provider and the types of drugs and things that are being distributed, going to that care for the patient, drug abuse in nursing homes does happen quite frequently. And as a nursing home provider, you have, if you're dealing with controlled substances, you have an obligation to make sure and report and take action. And that would be the type of thing that a state regulator would look at and say, you failed to provide adequate safety and care for patients. And that would be something that could come back to put you in a kind of jeopardy situation. Next slide, please. Just talking about, I wanted to give a couple case examples. This is from 2014. Omnicare was doing a promotion where they were working through patients' nursing charts and making recommendations to physicians on particular drugs that should be prescribed. The problem was, of course, that there was a financial relationship between the nursing home and the pharmaceutical company, which essentially impeded or interfered with pure medical decision-making. And that's really the test in these kind of improper relationships. Federal regulations are meant to have nursing homes protected from unnecessary drugs, but this solicited and received kickbacks in order to recommend prescription drugs for behavioral disturbances. Again, this goes to some of those restraints that Jennifer was talking about earlier, using narcotics or different things as a form of restraint to make it less burdensome to care for a particular patient. So this is a kind of, if you look in this settlement, I took this right off the DOJ news page. Talks a little bit about the types of relationships and the types of things that the government may look at. Next slide. So if you're advising a facility, you need to look at those relationships. There should always be a contract. It should be reduced to writing exactly what the relationship is, and it should be reviewed by counsel and evaluated under the various safe harbor and fair market value type exceptions and things. Additionally, if you have a procurement officer or the person who handles those contracts, you should ensure that they're regularly receive training on policies, compliance, and different things like that, and you have a clear record for them. It's very important. I know when it comes to these investigations, the first thing the government's going to look to, especially in that all-important exclusion or CIA decision down the road, is what's the training and compliance program, and was it being complied with? How effective was it? So these are things that you have to make sure you stay ahead of. Next slide. Now, as far as getting reimbursed, we talked briefly about this. These cost reports include various things like utilization data, charges by cost center, settlement data, financial statements, and they're all done on a form. So interestingly, it's not like a normal facility where the care you provide today you're being directly reimbursed for, or even directly affecting your your rates. It's a year behind typically, and it takes some time to get into the recalculation. But if for a nursing home that lasts over time, that is something that they're gradually doing, and there could be basis to insert amended cost reports if you find that there are changes in this data. Next slide. But the per diem is the all-important rate for facilities. Reporting patients in higher need and higher cost statuses as a routine matter can significantly impact that per diem rate. Obviously, a facility that's willing to take the difficult, most high-need patients should have higher costs, and the government has an interest in making sure that people are motivated to take on more difficult patients because they have to be cared for as well. But falsely indicating patients are at these higher cost levels when it's not needed over time is a problem. And this kind of false cost reporting, and we're going to talk about one place to look at this and where this is going to probably more significant now than in the past when we talk about the CARES Act and how significant this cost reporting could be. We take a look at the next slide. Here's another example. This was a recent settlement for nursing home chain Sabre Health. They were including some specialty care called rehabilitation therapy in order to increase their Medicare billings. So when you can change your daily rate for the high-skilled care in different layers and keep trying to put more of your patients into the ultra-high patient category, which include various objective criteria, 720 minutes of skilled therapy, 5 days a week when it has to be provided. These are all objective criteria that, it's pretty clear if you're falsifying that data, there'll be things in the records. And let me just make a side note. I meant to mention this earlier. Jennifer was talking about the wounds and things like this. Record falsification is a big part of what we look for. Wound care is one of the easiest ones to find. If we have a patient with, severe, open, complicated wound, like a bed sore that's at a particular stage, scientists or a doctor who looks at it would know approximately how long it took for that wound to mature, because it's pretty expected for most people. If the logs show inspected by nurse, a body evaluation, and they show it's constantly, clear every day, that's usually a good sign that the actual, maybe there's a staffing problem. They're not actually checking patients. They're just signing off on the list. And wound care is one of the big giveaways in that area. So let's move on to the next slide, a little bit more on this settlement. So, a lot of these have to do with expectations. And this is where, in many cases, it's a combination of things. You get into looking at the emails from the management, you look at the emails from the staff, and you look at the medical records, and you start to see, expectations. When you start to see budget projections that imply we're going to have at least this many ultra-high therapy sessions this year, we anticipate that many. And that's the kind of target type information that's an indicator when we look. Therapists to report time, when you have people when you see sample care notes circulated, identification notes and circulated. These are all indicators, not necessarily, could be totally legitimate, helping people, but you start to see it in a combination of factors. There's more and more things adding up that start to raise alarm bells about potentially medically unnecessary care and billing. Next slide. So let's talk briefly then about COVID and CARES. This is not going to be a COVID CARES presentation. There's many of those going on right now, I'm sure, and it's a constant issue. But the provider relief funds, and I want to talk briefly about that. There's a number of categories: the general distribution fund, phase 2, the nursing home facilities targeted distribution fund, the nursing home infection control distribution. These funds, and this is a challenge for everyone out there. And the PPP in some respects. But I'll talk about these PRFs for a minute. These funds often, at least the first phase, came in without anyone doing anything. No one applied for this money. It just showed up one day. And then there was conditions, and then there was more conditions, and then there was altered conditions, and then reinterpretations. It's a challenge to know what is, how this money is supposed to be used. But one thing that's pretty concrete is you're going to have to be able to show there's a loss or additional expense or something related to COVID for the use of this money. And I think that cost reporting really makes a big deal. If your cost report for year A, 2020, looks exactly the same as it did for 2019, and you don't have any additional costs related to COVID, you're going to have a hard time, unless it's on the revenue side or population or things that these are all things that the government's going to look at. So I think this is a trap for the unaware and people not paying attention. Is the conditions, and everyone it's all these funds. I know we've looked at them. You simply click on a button that's saying yes, we're going to comply. And these terms and conditions of the money, it's a complicated thing, and it's very important to take a very close look. And I'm not sure exactly what the enforcement will look like. I don't think anyone does. And whether or not you could prove rules that change after the fact. Are we looking at a kind of reverse false claim where you kept it even though they changed the rules and you knew you should have given it back? Is it really fair to ask people to give money back when at the time they took it, they thought they could use it? So those are all things to think about. There's going to be clear instances where it's misused, but I do think. Now, I don't know, Jennifer, is there any state-specific type CARES Act issues that that where there's funding from the state government or anything that you think about?
Not that I'm aware of.
Okay. Yeah. But I know that DOJ is already a task force. There's a special inspector general. It's just starting to occur, and I think that this will be. But I think these will all be buried in the types of fraud we've talked about. Is where this money goes and how it's spent is what we'll see. Let's see the next slide, please. Go ahead.
Just kind of going along the lines with the COVID/care issues. When we're looking at, and I think Tom touched on this a lot, what compliance with state and CDC requirements. So before it was compliance with the CARES Act regulations and requirements. This is also in alignment with what were what were facilities supposed to be doing throughout the COVID timeline? So much changed so quickly, whether it was CDC guidelines, Centers for Medicaid and Medicare Services guidelines, your state guidelines, what was going on at what point in time. So if you're looking at pursuing an action against a nursing home for either fraud or abuse, you really have to be clear on what the guidance was in place at the time of the alleged events. You cannot hold a facility to today's standards based on actions that they were taking in March or April, because so much has changed since then. Just as much as what PPE, right? So you were required to wear masks. You weren't required to wear masks at the very beginning. Nobody knew. But other issues regarding things like PPE, are facilities charging? Are they built? Are they reporting those on their cost codes, but then they're not actually providing them to the employees? We've seen instances where the personal protective equipment had been locked up, and then state surveyors would show up and it would be dispersed. And then once the state surveyors left, the PPE got locked back up again, right? So just be aware of what's going on, what the requirements are, and keep looking at how are things actually being used. Visitation is an issue, obviously. I think we were starting to see throughout the country where facilities were opening up and there was outside visitation, and even facilities were beginning to allow in-person, inside visitation. Now, with the whole country kind of backsliding back into a bad COVID situation, we may see those restrictions start tightening again and closing down visitation. Hopefully, our state surveyors and local ombudsmen will still be able to enter the facilities, because it's hard to look at and and know what's going on in the facilities without outside visitors entering. One place, again, we talked a little bit about discharges. Their discharges, let me back up. With COVID came a lot of waivers. One of the waivers had to do with discharges, and CMS looked at discharging patients during COVID and waived a bunch of the notice requirements, the written requirements, whether a resident could refuse to share a room with somebody or change a room, so on and so forth. And those were waived for purposes of cohorting. So you can now discharge a COVID positive resident to a COVID positive only facility, or a COVID only wing, a COVID positive wing. You could take a COVID negative resident and put them in a COVID negative wing or a COVID negative facility without the 30 days advance notice, so on and so forth. So again, if you're looking at a case based on bad discharges, know what the rules were, know what waivers were in place. COVID only facilities. This is a place, at least in California, we have a number of facilities who were able to self-designate themselves as COVID only facilities. So they were accepting COVID positive patients only. As it turns out, they were some of the worst performing facilities in the state. So here again, you have very bad performing facilities providing substandard care, who now are taking on COVID patients who have higher acuity levels, more precautions need to be taken, probably more staffing you've got a don and doff. So this is an area that we can look at too, because the COVID patients provide a higher reimbursement from Medicare. So keep an eye out for facilities who are going COVID only, or who are maybe designating some non-COVID residents as COVID positive in order to get that higher reimbursement. And then I think the last thing on this I want to talk about that's not on the slide is just be also aware of the immunity laws that were enacted during COVID. I think the latest numbers I heard, I think 31 states have some sort of immunity provision, whether most of those I believe are just civil. I know New York has criminal. I'm not sure who else has waived criminal liability. I heard actually at the tail end, or maybe in the middle of a presentation earlier this morning, that Massachusetts is the only one of those 31 states that had carved out false claims actions out of that immunity statute. So even though there is immunity in Massachusetts, you're not immune for claims brought underneath the False Claims Act. So again, if you're looking at COVID type abuse, neglect, or fraud, make sure, one, you know what the immunity status is in your state, and then also how things have shifted and what requirements have shifted throughout COVID. Next slide, please. And then finally, if you guys, for some reason, don't think that this is in the spotlight and you haven't been watching the news, the Washington Post came out with an article on August 4th about the use of CARES Act money where the headline is nursing home companies accused of misusing federal money received hundreds of millions of dollars in pandemic relief. So basically they did a survey and looked at all the facilities that received CARES Act funds and said these companies were responsible for, or were at least accused of misrepresentations to the government. They were accused of widespread failures in patient care. They were accused of falsifying documents and all sorts of other issues. So don't expect this issue, the issues with the CARES Act funds, to just disappear. It's not going to. I think it's going to be big news for a while. And with that, I think we are done. So we have some time for questions. So we're ready now to begin taking questions from our audience. You can submit questions via the question feature on the webinar interface. It's on my screen, at least it's to the right. I don't see any now, so we'll wait a few minutes. All right. Okay, and then if you do have questions and you don't have an opportunity to put it in, or you don't feel comfortable, or it comes to you later, you can always contact me. I can't remember, but I think our email addresses were on the front. But if not, I'm at California Attorney General's office. My name's Jennifer Euler. That's in the bio. And Tom, I'm sure you're available as well.
I'm at Baker Donelson. I think the email's on the front, but
yeah, if you
go to the website, you can find us. Interesting question, Jennifer, as you look at this. Have you, while we wait for some questions, maybe we can just chat. Are you aware of any, the nursing home initiative that you mentioned about Attorney General Barr announcing? Has the state or states that you're aware of announced any parallel initiatives or anything like that?
Yeah, I believe Florida may have come out. I'm not aware of any specific state only in conjunction with it. I think all of the state MFCUs, that is our mission, or part of our mission, is to look at nursing home and nursing home fraud and abuse and neglect, and we focus very heavily on that. So though I don't think that there's I know at least California does not have a specific initiative, it is something that is always on the forefront for the states, at least ones with the MFCU.
And maybe you could talk, while we're just waiting a few more minutes, of the relationship. Obviously, a nursing home, many people are paid by Medicaid, so it's an MFCU type case, but it's also, there's a federal component. Talk about how the state works hand in hand, say, with the HHS OIGs, and how those lead and what people can expect when they're dealing with that.
Yeah, so it depends on the type of case and who gets the case and who gets the referral. But we, at least in California, and I'm pretty sure this happens throughout the nation, we work very closely with HHS OIG in these types of investigations. Sometimes our agency takes the lead, depending on who the referral source is. And then if we see, okay, there's a lot more Medicare involved in this than there is Medicaid funds, we may say, hey, HHS OIG, do you guys want to be involved in the investigation and prosecution? And then our agencies work it collaboratively. A lot of the times we, for like False Claims Act cases, we do our DAGs, we call them DAGs out here, our attorneys are involved in global cases. The MFCUs have a national association. It's called the National Association for Medicaid Fraud Control Units. And so quite frequently, if there's a False Claims Act that affects more than one state or the majority of states, MFCU teams, which include representatives from certain of the state MFCUs, will work together, usually with the AUSA, to work on these cases, investigate these cases, and come to a potential global settlement. So there is a lot of cooperation between the MFCUs amongst themselves, meaning the other state MFCUs, as well as with the federal government. All right. Well, I don't see any questions. But again, our information is available if you guys have something you want to ask offline. So before we leave, I just want to say thank you for joining us today. On behalf of the American Bar Association and the ABA Criminal Justice Section, I'm Jennifer Euler. That's Thomas Barnard, and thank you all for joining us. Bye. Thank you.
Bye. Thank you.